he was alleged, he was alleged to have been in the polling place, but he wasn't at the election commissioner, had the credentials, so you all dismissed the case.
Because there weren't actual
Different. Right. Right. So
I see what happened.
Okay. Yes. Yes. So the respondents that are remaining are all here.
Correct.
All right. Great. Thank you. All right, Mr. Biss, your complaint. We have, just so you know, we have in the record the complaint. You don't have to necessarily repeat everything that's in there, of course. But if you have additional information, like to present the evidence, you're welcome to do that this time.
So, Mr. Chairman, for the record, Mr. Brezek was dismissed as to the original complaint, but there's also dialogue on the record at the last meeting this was continued from, that an additional charge was going to be discussed in dialogue at this committee meeting. That's what Mr. Weiser so viscerally objected to at that meeting, and it was agreed upon by this board that they needed to move this to November 18 so that he had opportunity to assess the additional charges of obstruction of a poll worker with his duties to this particular hearing. That's found in the minutes of that last meeting.
No, that's what the Barnhart matter, which has been continued. Yes, I agree with Mr. Biss says, but that was another matter. That was the Barnhart matter.
It was Barnhart.
Yes, and that was,
Not this
and
particular.
we were notified on Thursday or Friday by the election staff that that matter had been continued.
This Barnhart
Could be available.
Yeah. So,
And
I mean, Mr. Biss, are you indicating that in this matter, 2025-01, there's an additional charge that Mr. Brezek has to address? Because I'd have to go back to the minutes and look at that.
Correct. That was part of the dialogue that happened at that meeting. There was significant discussion at that meeting as to whether or not this board had the capacity to bring up, based upon loose allegations, additional investigations and charges. It was identified the board that they had done so in previous instances.
I remember Mr.
Weiser,
Mellon
yeah,
making that.
Mr. Weiser appropriately objected to and said it's inappropriate to bring up a new charge at this time. And at that board, I believe the board appropriately said, yes, Mr. Weiser, you need additional time to review this claim with your client. Let's delay this until a later date so that you have opportunity to work out things, questions, information with Mr. Aigner, and let's revisit that at that time. And it was going to be the obstruction of a poll worker with his duties claim that was going to be additionally reviewed today. So,
But the complaint was during that.
Yeah, I have to look at those minutes to see. I mean, I'm not disagreeing. I just recalled it differently. And I thought it was part of the Barnhart matter. All right, well, Mr. Biss, how do you want to proceed then with Mr. Brezek's absence?
well, I guess it would be appropriate if Mr. Brezek was here so that he could respond to it. I think the American judicial way would mandate that he should be, very candidly, as an arbiter of the court, much like yourself. If someone's going to face charges, they should have an opportunity to hear them and respond. So I think it'd be very
My
appropriate.
query was more of, given that he's not here, did you want to continue the whole thing? Did you want to continue just the part about Mr. Brezek, given that he's not here? It's your complaint, so I want to make sure you have the ability to present your case as you wish.
Mr. Chairman, I think it'd be wise to move it so that everyone's here at the same time. That way we're not being duplicitous with everyone's time. Otherwise, they'll have to be hearing it twice.
And I do know that people are here and they've taken time out of their day, so that's another thing I want to consider. Ms. Brandenburg wanted to hear.
I was going to suggest, and I would need to look at minutes
Yeah.
too. I don't have a great recollection of this, but I know that there was an aspect of Barnhart's claim that related to obstruction of poll worker. There's also an aspect of the Eichner claim that some complaint that states that Mr. Brezek was present and kind of encouraging of on the poll site as a deputy election commissioner. If the board wished to bifurcate that issue, Mr. Brezek, since there may be some confusion here, Ms. Barnhart requested the continuance. He does have to come back for Ms. Barnhart's complaint. Perhaps that aspect could be separated and severed because it is a bit of a different issue than what you're dealing with poll workers themselves. That might, in fairness, give everybody time to prepare and assess.
All right, Mr. Biss, given what Ms. Brandenburg said, do you have any issue with bifurcating Mr. Brezek's case? Again, it's your case. I don't want to tell you what to do. I'm just asking.
I don't have an objection to that. They're so intertwined, but we'll do our best to try to be streamlined.
Okay.
If that's what you desire.
All right. So, Mr. Weiser, do you want to be heard on that? On that issue?
because I'm not sure I understand what that. First of all, let me just say that and apologize. My understanding at the conclusion of that meeting, and I haven't minutes either, was we were talking about the complaint Ms. Barnhart filed against Mr. Brezek involving a whole different polling place and an issue regarding the different polling places. And that's what I was reacting and responding to. I did not recall, and I'm just going by what my recollection is, that it related to this case at all. And if it relates to this case, then what's going to happen is these same people are going to have to come back anyway because they're going to have to be witnesses, or at least several of them. And I wasn't, and I'll be candid, I wasn't aware that there was a further issue about obstructing poll workers. I knew there was in the Barnhart one.
I remember Mr. Mellon bringing this whole idea up of, being able to amend or add another count, and then you being able to have time to respond to that. I just didn't remember it in this context, honestly. I thought it was the Barnhart case as well. But again, the minutes will tell us. It seems like it's kind of intertwined. I don't know if the board wants to be heard on this, Mr. Reed.
Well, I hadn't considered the idea that if they're bifurcated, these folks will probably have to show up again anyway.
Yeah.
So it's almost we're going to save a little bit of time in the next hearing, but not much, and we can do it all at once.
Yeah. Okay.
And it was, and as far as the Barnhart complaint goes, it was her motion to continue originally.
That's right.
So it's not like nobody's looking to duck a hearing. It's just how it worked out.
I know,
Yeah.
but there was no, or at least I've never received any additional filing as the representation.
That's why I think we got with the minutes, because it may have been oral. I don't.
Yeah, and I didn't receive anything different than what we got on May 8th.
And Mr. Biss is indicating that, Ms. Regner as well, are indicating that it was oral at the time, and then you asked, well, you said, look, if the board's going to allow this, I need time to respond. But again, I think we need time to look at the minutes. If it is intertwined, I agree with Mr. Reed. I don't want to waste time here. And I don't want to waste, first of all, let me say the people who came today to testify. I know the board all appreciates you coming. I know you took time out of your day to do it. What I want to try to avoid is having you stay here for 2 hours, come back in December or January for 2 hours and say the same thing for Mr. Breeze's part of this. So in that sense, I hope you understand I'm trying to actually save you a little bit of time, even though you're come out here twice. Given that, I guess, unless there's an objection from the board, I'll entertain a motion to continue the Aikner matter to a coordinated time. That'll give both counsel for the board and counsel for the complainant and respondent time to coordinate this and determine what exactly is an issue. For the board, I'd appreciate counsel for the board getting us a little memo on what's kind of left and what's out there. Give us some direction. All right. In that case, I'll entertain a motion to continue if I don't hear anything.
So moved.
Second.
Motion by Mr. Reed, seconded by Clerk Brown, to continue the Aikner matter until a date that's coordinated. Is there any further discussion on that? It may be, and I think that all depends on where we end up with the minutes and everything like that. I think it may be.
Is it your actual question? Because I like that it's so much of an intertwined, everyone, different vote.
I agree with you. Yeah, and if we can consolidate these two cases, I would encourage the attorneys to consider that so we can all hear it all at once. All right. I'm sorry, Ms. Miller.
I have another question about, I know that there's been discussion that the motion was made orally. It was made orally. I'm wondering if, as part of the motion, we could include that be provided to the respondents.
Sure. Yeah, it would be in the minutes, I think, but I would ask Mr. Biss to make sure everybody understands what the allegations are regarding that.
I'll provide that to Mr. Weezer.
Okay.
That's well taken, Ms. Kendler. Thank you. Any further discussion on the motion? Hearing none, all those in favor, signify by saying aye. Aye. Any opposed? That motion carries. Thank you all. Again, I apologize for your time here, but hopefully we'll save you some time in the end. You're free to go or stay with you.
No, I know.
Next time.
We got some depths too.
Oh yeah.
Lisa was the one.
I was asked to that part, but it was there.
Cleared the room out.
Okay, while we let the room clear out. Slowly but surely going down, I'll be on my knees. All right,
You want to sit on my lap?
you have me? Okay.
Pony ride.
I was thinking, the next matter for the board under old business is Siegert versus Flores. I do see Chief Flores here. Good morning, sir. Mr. Siegert's here. Can I swear you guys in real quick? Would please raise your right hand and stand. Thank you. Do you swear the testimony for this morning be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. We'll show you both being sworn. Mr. Siegert, just to set the record, you presented a complaint. Mr. Weiser filed a motion to dismiss, which is pending. I gave you time to respond to that motion to dismiss. I did not receive any response to the motion to dismiss, but I did receive what I guess I would refer to as an amended complaint that further flushed out the issues that you have here before the board. Is that fair and accurate? Yeah. Okay. Mr. Weiser, do you agree with that? My setting of the record as it relates to
I agree with your setting of the record. I don't agree with you, but I agree with your setting of the record.
Understood. So, because the motion to dismiss is still pending, and it relates to whether or not the complaint can, under the facts stated, rise to a violation of election law, I think we have to explore that a little bit first. And so, I don't know if the board has. I'll obviously defer to any board members first. I've got a couple questions for Mr. Seeger.
Are we just handling the motion to dismiss right now?
Yes, currently, I guess because I think we have to address that
so
before.
Motion to dismiss.
Okay. There's a motion to deny the motion to dismiss. Is there a second?
Second.
Second by Mr. Reed. Any discussion? Okay, so on the motion to dismiss, I guess, Mr. Seeger, my question to you is, you've alleged that there was a, for lack of, I don't know what these things are called, roadside, what do we call them these?
Portable road
LED
information
Yeah,
sign.
kind of what we see like
Highway information sign.
yeah, NDOT has them, right? These little, put them on the side of the road, like this road's going to be closed, whatever you should see. You've alleged that because it said Flores for sheriff, or I think that's what it's probably what
It's
exactly.
in the documentation.
There you go, thank you, Flores for sheriff. And that you then brought a complaint against the committee, Mr. Flores' committee, indicating that violated the disclaimer law. That
Correct.
Okay. All right. So the question I have for you, I need to get some.
Was there more to the discussion on that? Was there also a conversation about the ownership of that?
Yeah, that's what I wanted to get to.
Utilization of public property.
Thank you. Well, and the motion to dismiss though didn't really address that, but we can talk about that if you want. Because I guess if you want to talk about
what are we just trying to dismiss?
Mr. Weiser, in his motion to dismiss, is attempting to dismiss the complaint, as I understand it, for failure to, based upon the facts presented by Mr. Seeger, that the facts don't rise to a violation of statute.
That's correct, Mike. What I did was, the allegation in his original complaint was that it was either a local traffic violation. He doesn't say that, but that's what it amounts to. He said it could cause traffic delay, or it's on county property, and that might be illegal, or that might be inappropriate.
But the lack of disclosure,
That was
so
addressed.
the political disclosure, you're saying that wasn't addressed, and that's in his
Because
original complaint.
No, he never raised it.
Right, that's okay. It wasn't raised.
It wasn't addressed. Right, it wasn't raised. I'm sorry.
Yeah. Okay, so, Mr. Chairman, though, but that doesn't mean that that can't be raised because, like we've said in the past, that the residents, citizens aren't attorneys, are not familiar with the proceedings and exactly all of Indiana state law, and sometimes we find things in kind of their complaints that do rise to the level of election law violation. And evidentiary or preliminarily right now, as I look at the picture of the sign, I cannot see a disclosure button.
Okay, so let me just get I think I'm catching up now.
Our
So
attorney has
yeah, I think
Do you want me to kind of summarize where we were on this?
sure.
Okay, I'm sorry. The original complaint from back in August was very general and attached a picture. Obviously, the board could draw implications from that. This is a disclosure issue. But what the complaint itself raised was just, is this blocking traffic? Is there an obstruction? No real specifics about the disclosure issue. The motion to dismiss followed that. Subsequent to that, Mr. Seeger filed an amended complaint in September. That amended complaint is much more specific. It does raise the disclosure statute specifically. So, while, I think the board could well within its authority to just deny the original motion to dismiss and say the board always has the authority to investigate complaints when they come before the board and the board thinks there's a reason to do so. Or it could grant the motion to dismiss and it could look at the amended complaint, which is also on the agenda for today. Either way, the board's looking at the disclosure issue.
At the end of the day, what we're saying is whether we agree with whether Mr. Seeger could amend his complaint or whether he filed an amended complaint, we hear it today. It's all we're all going to hear it. All right. So if there's no other questions or concern about the motion, denial of the motion to dismiss, which is the motion, I should probably just ask Mr. Seeger if you want to be heard on that at all before we take a vote.
Just for clarity, as I understand, the vote is to dismiss the motion to dismiss.
To deny the motion.
Yeah, deny the
Correct.
motion.
And proceed with your amended complaint.
So my amendment then becomes valid and here.
Yes,
Thank
you
you.
got it. Mr. Weezer, do you want to be heard on part of the?
Well, obviously, I disagree.
Okay.
I mean, it's apparent. I mean, if you can start raising issues when no issues exist and when no issues are pled, then we're in big trouble. We're in big trouble with that approach to hearings, because there's a statute that says it needs to rise. It needs to be investigated by the board, and if it rises to the level of a complaint, then it's brought to the board for a hearing. I don't know how in the world a disclosure issue could rise to the level of a complaint when he never pled it, when he never even mentioned it, when he never even suggested it, and never even suggested that any campaign law had been violated. And now the board seems to be taking a position that doesn't make any difference. They could say, the moon is made out of cheese. It doesn't make any difference what they say. We're going to hear it. And that's not consistent with the statutes, and it's just wrong.
All right. Thank you, Mr. Weezer, for that. I guess is there any other discussion on the motion? Not on the motion. First round. Oh, I'm sorry.
I'd like to respond to that.
Well, we're not going to have any response to that right
Well,
now.
I might just refile another complaint.
You're welcome to do that if you want. Right now, we're just trying to figure out if we're going to deny this motion.
So the issue here is, based on his complaint, is there enough evidence to move forward?
No,
or are we just going to listen to it because he filed a complaint?
So right now, yeah, I'm sorry, the way I understand Ms. Brandenburg is that originally Mr. Seeger only filed a sheet of paper with some photos. Mr. Weezer properly objected to that, filed a motion to dismiss. We took that under advisement and gave Mr. Seeger time to respond to that. He did not respond to that. However, he did file what I would either consider an amended complaint or a new one, which was filed on 9/17. And that is also on you. So
You're going to hear this one way or another.
it sounds like that's the way. Yeah.
Mr. Chairman, I have no
Mr. Mel.
problem upholding the motion to dismiss. Feel better. But keep in mind that the board has the authority and the ability to investigate on its own when it sees an election law violation.
What amazing.
What has the potential to be an election law violation, and can bring it before this board and we can have this conversation. So we can dismiss that complaint. We could set this for another hearing. We could bring everybody back in a future date. I'm perfectly fine with that anyway. But this is going to go through a hearing because as I look at this picture, I can see there's not a disclosure block anywhere on it, or it doesn't appear to be, and maybe somebody can point out to me what there is, and we can have that conversation. But that conversation, also the ownership of this item needs to be discussed, and the complaint. If the complaint doesn't address those particular issues, as though we see them now and they were discussed during the meeting, and we've done that in the past, that's been kind of our history. Another complaint could just be filed, and you've even said that there's another complaint that's already filed. So vote either way on this, I guess. But in the end, we can reset this for the next month.
Well, I think it's set. I think we're ready to hear it.
Yes.
I think we're ready to hear it. I mean, at the end of the day, I think that it's a good thing for the board to hear complaints that may rise. That doesn't mean that they do, because a lot, we can still dismiss the complaint later if it doesn't rise to a violation of election law. But it's a little form over substance at this point, in my mind. So I'd rather get to the vote, move through it, and then if we're hearing the new complaint or we're hearing the amended complaint, I think it's about the same. So in my mind.
And what's the motion again?
Motion is to deny the motion of dismiss, which is the original. It's to dismiss the original complaint.
August 20th complaint. Basically procedure. The first, the amended consent.
Yeah. So the original complaint looked like this, if I remember right.
It's 4C.
That's right. 4C.
4C. So the motion to dismiss depends on 4C.
All right, we got to talk to the board here. This whole thing. All right. Motion in favor would be to deny the motion to dismiss, and that's the motion. So, all right. Roll call, please.
Mr. Reed.
Yes. Yeah.
Allen.
Yeah.
Mr. Brown.
No.
Mr. Reardon. Yeah. Mr. Smith.
No. All right. So I don't know where that leaves us, but we do have before the board a new complaint.
Well, I hate to bring this up as a matter of procedure, but I don't think that motion to dismiss was granted. I think a motion to deny the motion to dismiss was denied.
Correct.
Right.
So there's still a pending motion to dismiss.
The original complaint.
And I say as another matter of procedure, I don't know, like court rules don't apply. We're not doing rules of civil procedure. But if somebody files a motion, may I, Michael? If somebody files a motion to dismiss, it's not infrequent that someone just amends their complaint. Agree response. I file a motion to dismiss. You fail to name a proper party in interest. I file a First Amendment complaint. Motion to dismiss denied. This really isn't any different. I don't think. But I will say, I mean, the initial complaint says, well, this might have caused a traffic hazard. Well, we're not the traffic. Right. So, whether the initial complaint stands or not is really.
I think at the end of the day, we're going to be amended or whatever we want to call it, amended complaint or new complaint. That's what we're going to hear.
Yeah, we're not going to. I mean, I find it unlikely our attorneys are going to tell us that we should make a ruling on a traffic issue.
Well, but just historically, we've taken complaints like this that don't mention, and somebody says, "Well, this is obstruction." Somebody mentions, "Well, this is obstruction before we're doing the job, and this is this problem, or this is this problem," and then we continue with that same complaint, and nowhere in those words. So now, are we changing back to the old way of doing things, where it's got to be written in the complaint? We're not changing back.
I don't feel that way. No, I feel that I feel that that. What was, to me, this does not raise anything. I think the amended complaint does, and I want to hear that. I want to get to the 9/17/2025 and see where we're going with that.
On the initial complaint, we had the pictures of the sign, right?
Yes, the pictures were there, but again, as the complaint reads.
And so I, with my own eyes, could see that there wasn't a disclosure bond on that sign. It was
But that
impossible.
wasn't the complaint.
And that was
But historically, this board
I think what Mike
has-
is worried about is the board's authority under IC 6-5-31, which states that if the election board determines there's a substantial reason to believe an election law violation has occurred, it shall expeditiously make an investigation. So the board, essentially what Mike's saying, and that's been bothering him the last several meetings, fucking up our minutes, is that if we just receive a picture with no information from a complainant, and the board then has some reason to believe that there's an election law violation, the board absolutely has the authority under that statute, and in fact even shall investigate.
Well, generally what we do is we direct our attorneys to look into it and get back to us.
But I can't get back to you more than to say this is a picture of the sign.
Right.
And that was the discussion last time, is we went through this and we said, and our attorney said, yeah, That's potentially an election law violation. But it's not in the complaint.
Right.
I don't care if it's
But I don't
we've
remember them
never
saying
cared
that.
if it's in the
I don't remember them ever saying that.
And pardon me for not being on last week, but then don't we get here with the second complaint?
Yes.
Because it
That's why I
basically
didn't.
alleges the same thing in the 917.
Well,
This is not an
doesn't
analogous. This is not an analogous case because we have an amended complaint. But I agree with Mr. Mellon. If we didn't have an amended complaint, based on our new way of doing things, we should be able to move forward on any violation that we see. I don't care whether the complainant spelled it out or not.
And I guess,
But this is not that situation. He did spell it out.
This one's easy. But had he not amended this complaint, the notion that we would not hear this right now is ridiculous.
I think the cleanest
Based
thing
on-
at this point would be to just go ahead and grant the motion to dismiss, close out the first complaint, go forward with the second one, just to make everybody kind of, I think that's a path of least resistance here to get you where you want to
But
be.
we just,
But
we
it's still
keep
an
flip
important
flopping
issue
on
that I know
precedent.
you care about. So,
It's-
and we all do.
but I think, Mike, or Mr. Mellon, I guess what I would say, just in response to that, I don't feel like we're flip flopping because it just is a difference of opinion on whether or not what was presented gets me to the point of, oh, this is what he meant. It may rise to a election law violation. So let me interpret for the complainant what it was. I didn't look at this and say, oh, this is a disclaimer issue. I had no.
I did.
You did.
I absolutely.
Well, that's what I'm saying. We have a different. That's
but
what I'm saying. We're not.
But it's
we're
a
not- well,
motion
let me
to
finish,
dismiss.
let me
All I
finish.
want to do is have a discussion.
And I do too. But
And
I don't want you
with
to. But I'm not
writing
going
a
to.
motion to dismiss. You don't
Okay.
have a discussion.
But I'm not going to sit here and say we're flip flopping because I think what we have is just you and I see what was presented differently. That's all.
You see it.
I don't see it as. I don't see what it is. I see a sign and him saying I think might be located on county property, possible obstructing traffic. Yeah.
You can't see an election law violation potential, not a potential in that sign. Really?
I mean, if you want me to extrapolate into what he might have been saying, maybe.
Well,
but I'm just going by what we
It
presented.
goes further than that too. Other than some private neighborhoods I do work for, the government primarily owns those signs. Now, can you rent them and use them for other things and festivals? Maybe, I don't know.
You
But
can.
generally speaking, those are usually government property. You got an area too many people are speeding, put it up. You're going too fast. Slow down. There's kids here. So I don't know who owns it. I don't know any of that stuff. But I do know that if we see something that we think possibly rise to an election law violations, and our attorneys do, I don't care necessarily that the layperson didn't know subchapter and verse of the statutes in Indiana to be able to make a complaint.
Yeah,
Hardly anybody does.
Mr. Reed, I don't disagree with you. I think it was just a disagreement in my mind over whether I saw that or not. You guys say it did. I say it didn't. I don't think that's flip flop. Mr. Clerk Brown.
Yeah, thank you, Mr. Chair. So as an elected official who deals with campaigning and whatever, you can't stop someone else from putting a sign up. That sign is up there. He may not have known anything about it. Someone else could do the exact same thing to me.
Yeah.
They put a sign out there and say the same thing without my knowledge or permission.
Sure.
So let's not be so quick to say, what's the
No,
election
I think that's what
law?
we're going to get into.
Oh yeah, Mike. I don't disagree. There could be a myriad
That's my
of
point.
legitimate answers to these
That's my
questions.
point.
I just want to have a hearing. Yeah.
I get it.
But you
Not-
dismiss the motion.
but not that way.
That's legal. I think
Is there a motion to dismiss the original complaint?
So moved.
Thank you. Ms. Candelaria Reardon, a motion to dismiss the original complaint. Second by Clerk Brown. Motion by Ms. Candelaria Reardon. Any discussion?
You don't want to discuss that originally.
I think it's all included in the amendment. All right. We'll enter. Okay. Any discussion? On the motion. Hearing none. Roll call, please.
Aye.
Yes.
No.
No.
Yes. All right. Original complaint is dismissed. Now we have before the board, Mr. Seeger, a document that was received by the election board on September 23rd of 2025, dated September 17th. You wrote that, sir, correct? Yes.
In cooperation with me, yes, it was written.
Okay. And I didn't mean to imply you didn't write it. You submitted this. You
Yes.
signed it.
Yes.
And this is your complaint before the board. It's entitled Political Sign Violation. I have a 3-page complaint as well as a photo from a Facebook page and a photo of the sign that you filed with your original complaint. Is that
Yes.
correct? So 5 pages in total.
Yes.
All right. Mr. Seeger, you can be heard on your complaint. And just know that we already have everything here, so you don't have to read it or anything.
I would like to explain my journey in signage, political signage. My HOA saw fit to fine me for posting political signs to the amount of approximately $5,000. Says, well, I knew nothing about political signage. I thought it was my right as a citizen to post what I want. They proceeded to do that, and with some involvement with lawyers and so on and so forth, they apologized and refunded my money, or reversed their citation. In the process, I learned about what is a legal political sign. Well, now armed with this information, I thought, well, that's a good thing. Laws are to be kept because rule of law matters. And I saw this sign, and I said, wait a minute, this sign doesn't conform to what I had to do and almost had to pay $5,000 for. So I thought, well, let's let everybody play by the same rules. So I provided the initial complaint, and now this subsequent complaint as articulated in my submission.
Okay.
And I'd like the board to rule on it and make whatever necessary referrals to, if there's necessary prosecution, if it sees fit to do that.
All right. And counsel, what's the disclaimer statute?
3-9-3-2.5.
39.
393.5. Excuse me.
93215.
It seems to be listed on the complaint page. If you don't want to
Thank
look
you.
at your books.
Got it.
On 4A, page 1.
Yeah, I just don't necessarily always trust something that's filed.
I understand that. Yes.
Yep. Thank you, though. And I have it. Okay. So, thank you, Mr. Seeger. Anything else you'd like to present the board before we ask any questions?
Not this time.
All right. Thank you, sir. Any questions of Mr. Seeger? I have one.
Excuse me, I'd like to recant that.
Sure.
I want to also mention that the direct acknowledgement by Facebook indicated acknowledgement and acceptance of this sign as being part of the election process for that committee and for Mr. Flores. So to me, that seemed like a prima facie admission that, hey, I like this. Seemed to be pretty clear based on Facebook acknowledgement of the sign, not just the presence of the sign.
Thank you. All right, Mr. Seeger, I got a couple questions for you. I'm looking at the statute, and subsection B of 3-9-3-2.5 states that this section applies whenever a person makes an expenditure for the purpose of financing communications. Do you have any evidence, or do you know whether or not Mr. Flores financed this communication that you?
I do not, but that could be an in-kind
I understand
contribution.
it could be, but do you have
That
any
would be my
indication?
suggestion, that until that's investigated with the filings, Mr. Flores will provide the board in time. That would be an in-kind contribution.
But you don't have any proof, as you sit here today, any evidence presented to the
I
board.
have-
I'm not faulting you for it, but
Yeah.
you don't have anything.
Yeah, I have no evidence either way that that sign was in kind or a direct payout from the committee.
All right, Andrew, Mr. Mellon. Yeah, go ahead.
I had a question about, you mentioned something about Facebook. I'm not sure I followed the logic there. Are you saying that the campaign acknowledged the sign, gave it a thumbs up? Can you be a little more specific on that?
Yeah, I'm saying Flores for Sheriff, Facebook.
Yes.
Whoever owns and operates that, I don't know. But it appears that there's an acknowledgement and acceptance of that sign as part of the campaign.
And
So whether it's in kind,
how was that acknowledgement done?
I can give you a copy of this.
It's on page 4A.
Or
If you want to just look
It's
at
in the
it.
chat.
It would be Flores for Sheriff. This sheet. That was not part of my original filing because it was subsequent to my filing.
Okay, Mr. Seeger, I'm sorry, Mike, are you done? Mr. Mellon?
No.
I'm sorry.
Or no, I'm sorry, yes.
Okay, so then the question I have for you, Mr. Seeger, is this Facebook post. Is there anything in here that you can point to that says that the communication was authorized by Flores for Sheriff?
I don't know that.
I didn't
but
ask if you know it. Is there anything in this document that says it was authorized? I wasn't sure.
it implies, in the vocabulary implies that it's accepted, acknowledged, and received as either in kind or direct authorization.
Where in here
It's
does it say
implied.
accepted? It's only implied. Okay, so nothing that says explicitly that. And where's the implication that it is authorized or approved or?
Second sentence, we love it. Thank you to all our volunteers for helping out at our booth and all the great people who stopped by over the last 10 days. We had a blast. So we love it. Thank you to all our volunteers. So that
For helping
implies,
out at our booth.
yeah, all our volunteers
For helping out at our
for
booth.
helping out at our booth. But we love it says to me, we accept it as an in-kind donation to our campaign.
Okay, so let me just understand. So we love it. I'm looking at the statute, and I don't see anything about approved. I see authorized, but you're saying that we love it should be implied to mean we authorize this.
If they acknowledge it as an in-kind contribution.
But acknowledge isn't in the statute. Yes, Mr. Mellon, absolutely.
So you're saying these two sentences go together. In case you were near the fair last night, you may see this sign. We love it. That's it. Now the other aspects you're saying are different.
Yeah.
You're saying now, thank you. By the way, thank you for our poll workers or whoever's running this site. So you're saying that they love it is an acknowledgement that they saw the sign.
That's correct, and that they're accepting it as an in-kind donation.
Mr. Chair.
Okay,
I think
Clerk Brown.
I think we're going a little too far with that. It's okay for someone to post something, have people monitor my Facebook page, put things down. My daughter started my Facebook page. And the clerk's office is about to start a Facebook page for someone else is going to monitor. But somebody said we love it. It has nothing to do with any kind. It has nothing to do with any money. Why I can understand, in your situation, when you posted something, organization had issues with, you worked it out, right? I think this is a little bit much. I think to say that this is in kind and it's political is a little bit much. I think someone just said they had a good time. Thanks for coming. Appreciate the volunteer. And it might not have anything to do with the candidate at all. That's what I'm trying to get you to understand. Because people come to my Facebook
No, this was
page,
posted by Flores for Sheriff.
but that
which
doesn't
is
mean
an
anything.
official website.
That's my point. I'm trying to get you to understand. I'm trying to be reasonable. I'm trying to get you to be reasonable because sometimes people. In 2008, when I ran for re-election for a recorder, I had someone monitor my page for me because I didn't have time to do that. So I was busy running the campaigns. You follow what I'm saying? And they would do the Facebook aspects of it. I'll probably do that again next year. But I'm trying to get you to understand, we have to understand just because we have a bad experience with these things, it doesn't mean our experience is their experience. I'm trying to get you to understand it's okay for someone to put this on having nothing to do with money, having nothing to do with his campaign, having nothing to do with him as an individual. That's all I'm trying to get you to understand. Because I see you on a regular basis. We have a great rapport. And I don't want all this to get crazy because we all know 26 is going to be a big election. So let's try and, ease back. And if there's no clear evidence, it's just an assumption that this happened. And that's not what we're here for. Assumptions. We're not here for that.
Thank you. I'm sorry. Thank you. All right. Any other questions of Mr. Seeger? Mr. Reed.
I have one question. It seems like we are putting the cart before the horse. I am yet to hear the defense that this wasn't mine, I didn't pay for it, somebody else did it, but we're assuming that he didn't.
Well, I'm just questioning during his case. I think those questions need to be asked to Mr. Flores.
Okay.
But I just haven't got there yet. I just want to give our board a chance to talk to Mr. Seeger.
One of the questions that could or should be asked
Yeah.
of Mr. Flores is who controls this site?
We're going to get to that, I'm sure.
Yeah.
All right.
Uh,
Any other questions of Mr. Seeger? All right. Thank you, Mr. Seeger. We appreciate it. We will show that your case has been submitted. And Mr. Weiser, would you like to be heard in response before if there's any questions of the board?
I'd like to question Mr. Seeger.
Absolutely. Oh, Mr. Seeger, yes, absolutely. You have the right to do that. Go
Okay,
ahead.
thank you. Mr. Seeger, at the outset, I wasn't thinking about this at the time, but at the outset, the chairman asked you, did you prepare, and did you write this? And you said in cooperation with someone. Who was it that helped you write that?
several individuals.
Who?
I don't remember.
You're alleging of, excuse me, you're alleging a violation.
I
Well,
don't
it's not a
remember the
question,
full
I would
list.
never raise the question at all if he hasn't raised it, and it is relevant, John, because he's making certain allegations, and he hasn't done any investigation, obviously, we'll talk about that in a second. So you are submitting an
Well, let me
amended
revise
complaint.
that.
Let me finish my question.
Okay.
You're submitting an amended complaint, and you're acknowledging people assisted you, and you have no idea who that was.
No, I'm revising that. I'd like to correct that, please. Those individuals that I trust and recognize as being capable in providing this kind of information.
Well, that doesn't answer the question, but we'll move on, because I don't waste time on that. When you submitted your amended complaint, and your complaint, and I want to make sure that this is correct. Your complaint is against Flores for sheriff, correct?
As it states, it is against the posting of the sign without disclaimer by whoever. I don't know
Who
whoever.
are you
whatever
complaining
authorized.
against? Who's your complaint filed against? Against what entity or what individual? Who is it against?
I am bringing it to the board for their evaluation and investigation.
So your complaint is not against Flores for sheriff.
My complaint is to the board for them to conduct an investigation to find out who and what, where, and why.
Oh, okay. So in other words, you're not asking them to make a decision. You're not saying that Mr. Flores or his campaign did anything wrong. You're just saying, hey, take a look at it and investigate it, guys. I don't know. You just find out for yourselves. Is that correct? That's what you want to do.
I'm alleging that the sign is not conforming to election law and therefore is a subject of investigation and or referral to other authorities.
When you file, just to make clear.
That's how I understand it. That's how I understand his complaint, is that he's saying, take a look at this, figure out what's going on. Is it an election law violation?
Have you taken it upon yourself, since you did provide the statutes, and apparently looked up the statutes that are applicable, and since you've done that, did you look up any statements of campaign organizations or campaign filings to indicate who you might be bringing this case against?
I'm a layperson and I don't have the authority to try anyone or bring a case against anyone or make a filing in the court of law. Therefore, I brought it to my only venue of appeal and address is to the Board of Elections. As a layperson, you're speaking to me as if I was a lawyer, and I'm not.
No, I'm speaking to you as somebody that's making a complaint against a
And I think
candidate
it's the
and
proper
besmirching his name, and
I
I'm
think it's
asking
the
you.
proper
let's
approach to
move-
investigation.
Thank you, guys. We're never going to get through this if we're going to argue. Let's just ask
okay,
questions,
are
Mr.
you-
Weiser, and answer questions, Mr. Seeger.
Then are
Thank
you
you.
aware of the fact that there is no campaign organization filed in Lake County or anywhere for Flores for sheriff? There is no such campaign organization that exists. Are you aware of that?
Again, I am not aware of details of it. I am not a lawyer. I'm bringing a case for investigation to the
Okay,
Board of Elections.
Next
and I
question.
get it. That's not the question. The question is, are you aware?
Well, he said
Either
no,
you
he's
are
not
or you're
aware.
not. Okay, all right. Okay, so you said you raised the statute. You brought the statute. The statute says that if you're going to allege a disclaimer violation, the statute says that the communication you must demonstrate that the communication is paid for and authorized by a candidate. Do you have any evidence to that effect?
I do not, and that's why I
Thank
brought
you.
it
That's
before
all
the
I
board
asked.
for their
Thank you. Thank you.
investigation.
Answer the question.
Next question. Just answer the question.
Okay.
I understand that you brought it before
It
us.
also says that communication must clearly state communication has been paid for by the authorized political committee. Do you have any information as to that?
I do not.
Thank you. It says if the communication is paid for by other persons but authorized by a candidate, are you aware that that took place and the other person was authorized to put up that sign by somebody?
I do not.
Thank you. I think that's where I'll end it.
All right, thank you. Based on Mr. Seeger's response to Mr. Weiser's question, does the board have any questions? Okay, Mr. Weiser, your next witness is or you rest?
My first witness. Well,
I'm sorry, yes.
I'll raise
It's your
this
case
again,
now.
just for sake of an argument. There still is no claim. There is absolutely no claim here. He's filed an amended complaint saying that against somebody, some entity, we don't know now. I thought it was against one, but apparently it says it's not. And so he's filed some claim and said there's a disclaimer issue. He supplied the statute. He's acknowledging that he has no evidence at all to demonstrate that there was any violation of the applicable statute. None whatsoever. So here we find ourselves again with no, and he got help. We don't know who, but a lot of truthful, honest people of integrity have looked at this, and they've all filed and said, don't know if there's a campaign committee, don't know who it is, don't have any information regarding who paid for it, don't have any information whether it was authorized by any campaign. I don't understand how we litigate these things at this level. It just doesn't rise. Carly read it before and said there has to be a substantial reason that it relies, that it meets the qualifications of relying through violation of the statute. He hasn't presented one substantial reason that it rises to the level of a campaign violation against an unknown campaign who has no idea if anyone approved anything at all, and yet how are we supposed to? We don't even know who we're defending.
Right.
So for that reason, I think he should be dismissed.
Sure, no.
Mr. Flores, or Mr. Weezer, whoever wants to ask the question, I suppose. Dumb question. So, Flores for sheriff, is that this Facebook site? Was that part of the campaign?
No, we'll if we're required to present evidence, we'll present evidence at that time.
Well, I'm going to say, I think you're going to present evidence, Jim, and I'm just going to tell you why. We cannot sit here in a bubble and assume that the LED sign store dropped this sign at the party. It didn't show up from outer space. Somebody bought it and paid for it. How hard is it? Why can't somebody just tell us who did it? If we don't know who did it, okay, we don't know. But I mean, we can't just have a sign show up without a disclaimer and say, well, I don't know. I guess it just showed up. I'm not going to sit here and play dumb.
John,
you can at least deny it.
I completely agree with you. It's not our burden of proof. I mean, we still have to operate under some semblance of legality. It's not our burden of proof. The burden of proof is on him to at least establish a prima facie case that we're involved or that he's involved. He's presented nothing that indicates that.
I've been gaslit before, but I can look here with my own eyes and I can see that there's potentially an election law violation in a sign. There's potentially an election law violation on a website. There's potential things. I have no idea if it's related. This could be some lunatic who's done all this stuff to besmirch him. I'd like to ask him the question. You don't want me to ask him the question.
No, I'll be happy to ask a question. I believe I have an ethical responsibility to my client. Yeah. I know legally this is wrong. I believe in my heart, not only as an attorney, but as a former election board attorney, as a former county chairman, that this is wrong. So I have an obligation to present this in the manner in which we're presenting. And if you all decide that it should go forward, then we'll present our evidence.
So are you saying you made another motion to dismiss? Is that what
you did?
You just did. Okay, I didn't hear
that.
All right. So there's a motion to dismiss before the board. I guess I would consider this after the close of the complainant's evidence, and it's Mr. Weezer again raised a motion to dismiss, saying that the evidence is presented by Mr. Seeger doesn't give us enough information to determine that it rises to a election law violation, therefore it should be dismissed.
I'd like to hear Mr. Seeger's response.
Yes, I was just going to say, Mr. Seeger, do you want to respond?
Yeah, I would prefer that the board would conduct an investigation, fact-finding, and find out the truth of the matter. And then from there, if Mr. Weezer would care to file a motion to dismiss rather than blocking, let the board do its due diligence to do the job that it was set to do. This is not a court of law. This is a informal public meeting that has implications of investigation by the board and a responsibility by the board to investigate thoroughly and completely of all those that are involved. I don't know the answers to the questions presented. However, it is up to the board to continue the investigation and come to some conclusion as to the validity of the observations and prima facie idea that there is a problem.
Thank you, Mr. Seeger. Mr. Weezer, do you want to
No.
reply? No reply. All right, there's a motion to dismiss. Any questions of Mr. Seeger? Okay, hearing none. There's a motion to dismiss. Vote in favor of being dismissed. The amended complaint. Roll call.
Reed,
No.
Allen,
No.
Brown,
No.
Reardon,
This is the motion to dismiss the entire.
Correct.
No.
Mr. Smith.
No. That motion fails, and we're going to continue. All right. So right now we're in Mr. Weezer's case, Mr. Flores' case. Mr. Weezer, it's your floor. You may present any evidence you want, or if you just want to have Mr. Flores be subject to questions by the board, we can do it that way.
Okay, thank you. I do have some written evidence. That's okay?
Yes.
Yes.
Yeah. Yeah.
And just for the record, Mr. Weezer is presenting to the board. He's handing each member 3 pages. First page is an IRS form addressed to committee-elect Stephen Flores. Second is a CFA 1 made out to committee-elect. Section B says committee-elect Stephen Flores. And page 3 is CFA 4, which of course is a campaign finance sheet with the name in section 1, committee-elect Stephen Flores. Mr. Weezer, we have made these part of the record.
Thank you. Which one? Okay. Would you identify yourself for the board, please?
Stephen Flores,
And what is your current occupation?
Chief of Police in St. John.
And have you been identified and have you identified yourself as a candidate for Sheriff of Lake County for the 2026 election?
Yes, I am.
In doing so, was a campaign committee formed on your behalf?
Yes.
And that campaign committee, including the IRS filing as well as the information we just provided to everybody, provided it. Is that correct? That's correct. And what is the name of that campaign organization?
Committee to elect Stephen.
Have you ever, in your seeking office for sheriff, ever in any way, shape, or form filed anything or any documentation, any campaign filings that you had to make or anything under any other name other than committee to elect?
I have not.
So there is no filing and there is no organization that represents you that says Flores for sheriff.
Correct.
Now, there's been, as you've heard, allegations or things that should be investigated, even though that's not your campaign. So first, it's not, Flores for sheriff is not a campaign for your system.
No.
So, as Flores for sheriff, in terms of, did you, well, let me go back. As the committee to elect Stephen Flores, have you, did you authorize, we'll get right to the point, did you authorize the placement of that particular sign that's the subject of this complaint?
I do not.
Did your campaign, did you authorize any other individual to do it on behalf of it?
No.
Did you pay for that sign?
I do not.
Did you contract for that sign?
I do not.
Were you aware prior to that sign going up and were advised of it that it was even posted, that it was there?
I was not. No.
And so you have no ownership interest in that sign at all? Is that correct?
Correct.
Okay, so it's not a sign that was acquired by your campaign.
No.
And I think we've also filed the most recent annual filing that shows that the sign was never contracted for, the sign was never authorized by the campaign. And so let me just wrap up. Just so we know, and you can let the board know in full transparency. When did you even become aware that that sign existed?
It was later that evening. I don't know when it was put up, but it was later that evening on the 10th is when I was made aware. I don't know.
And you didn't authorize it to be put up?
No.
And your campaign did not authorize it to be put up?
No.
And there's no evidence and no information at all that you, in any way, shape, or form, either paid for the sign or paid to have that sign installed?
Absolutely.
And it was never a sign that was placed on behalf of either you as a candidate or the committee to elect Stephen Flores as a committee?
That's correct.
I have no further questions.
Thank you, Mr. Weiser. Any questions of Mr. Flores?
Yeah, I've got a couple.
Mr. Mellon.
So you weren't aware of that sign. You became aware of it on the 10th. You don't know who did that, put that sign up, do you?
We do, yes.
Could you say their names?
Nick Petrovsky.
Okay. That Jack is the only person?
Yes.
Okay. And when Nick did this, is this his sign? Does he own this sign?
I believe so, yes. I think he's the owner.
Do you know whether he is?
Not 100%. I believe, yeah. I think from what he told me, it's his sign.
Okay. And so the sheriff of Flores cites where
Flores.
Flores for sheriff site where in case you're near the fair for the last night, you may see the sign. We love it. You're just. I read that as an acknowledgement of, hey, way to go, whoever's doing whatever you're doing. I assume you're doing it legally, so way to go, type of thing, because you had no knowledge of the sign or anything along the time. Is that your site, and is that you who wrote that, or is that something?
Yeah, I'm not denying that.
Yeah,
we acknowledged it, but we didn't pay for it. I had no knowledge it went up until after the fact, so I'm not denying that.
Okay. All right. And as far as you have no knowledge of the sign from a bug perspective because it's on your side. What about the website or the Facebook site? Is there
that's our
proper disclosure on it?
That's our
who pays for it?
Our Facebook page, correct? That's our.
Is it up today?
Yes.
Okay. And that Facebook page, if I were to go on it now, I would be able to see the disclosure that's paid for by. I would assume, what is it? CT Flora.
It should be on there. Yes. Yeah.
All right. No more questions.
Thank you, Mr. Mellon.
I just have one.
I had one too. Go ahead.
Oh, sorry.
No,
Chairman.
no, go ahead.
I was just going to ask you, did Mr. Petrovsky ask you to acknowledge the sign as giving him an in-kind contribution, credit, or anything?
Not at all.
That's all.
Not at all.
Mr. Flores, the question I have is, by placing the language on the website, we love it, did you intend that to be authorization for the placement of the sign?
Not at all.
Okay, that's all I got. Thank you. Mr. Seeger, you have the ability to question Chief Flores if you'd like.
So I want to be clear. The Facebook page is your official Facebook page that you use for the campaign. Is that correct?
Yes.
Any other questions?
Not at this time.
All right, thank you. At this time, Mr. Seeger, you're the complainant. You have the ability to reply to anything Mr. Weiser or Mr. Flores presents. It has to be focused just on what was presented. And it's okay if you don't have it.
This time I just got this document just now. I haven't really reviewed in the detail. At this time I have no particular comment.
All right, thank you, Mr. Seeger. Thank you. The matters before the board at this time, I'll entertain a motion unless any board member has any questions for either counsel, Mr. Seeger, or Mr. Flores.
I have a comment, Mr. Chairman.
Clerk Brown.
I think the board, in all fairness, even though when this gentleman presented this case, we wanted to make sure everyone saw both sides of it. So you just dismissing this. Now you've seen both sides, and you can clearly see he's a committed to it, not Flores and Sheriff. And you can clearly see most of this is just hearsay, great substance. But it's not a violation, so it doesn't matter. Make the motion.
All right, we have a motion by Clerk Brown. Complaint, is there a second?
Second.
Second by Ms. Candelaria Reardon. Any discussion?
Chairman,
Mr. Mellon.
I gotta have a couple of things that fundamentally I agree with Mr. Brown that I based on the evidence that's here, I don't believe that the signage was the signage that was put up. I don't think Ms. Flores authorized that. I don't think I'm aware of that. I agree with the statements, and there's no evidence to show that anything to the contrary. So I do agree with that. The issue that I'm having is Nick. We pronounce that. Petrovsky. Nick, I can't read my handwriting. Nick Petrovsky did put the sign up, and there's obviously not a disclosure on it. Election law violation still took place. Mr. Petrovsky is now alleged to have put the sign up in violation of election law. And as I did go to your Facebook page, I also went to your website, Flores for Sheriff. Flores for Sheriff does appear to have a paid for and authorized by the committee to elect Stephen Flores disclosure on it. I don't see that on the Facebook page. Could you possibly show me where that is?
Well, I mean, it's not necessarily before us at this time.
Why is it not before?
Because we have a motion to dismiss the complaint.
Well,
And it has to do
I
with this
think-
sign.
I think what
What I'm doing is I'm in the process of discussion.
can I help you?
Please.
I think what Mike is trying to say is the sign in question that Mr. Petrovsky put there, that the sheriff's candidate was unaware of, is that it was reposted on that Facebook page and still doesn't have its thing on.
I guess my point is, I would have no problems dismissing Mr. Flores, but I can't dismiss every aspect of this. And one of the things I think that we're required to do is if there is a violation of, like, the Facebook page, there's not disclosure on it, then it's our duty then to say, you were out of compliance, please comply. Now, the remedy for that is just him beginning to comply. I mean, we're not referring to prosecutors, we're not, going to hold him over his head, but by dismissing the entire thing in its entirety, and this is why it's part of the discussion, by dismissing the thing in its entirety and not being specific as to what we're dismissing, you're not giving me the opportunity to say, you do have a problem here, please fix it.
And I'm fine with you stating that. I guess my question
But I'd like
was
to do
you were
that
questioning, and you
well, because I didn't have the answer.
because I asked, do you have any other questions for Mr. Flores?
Well,
Everybody else, and we have a motion on the ground.
I apologize, sure, I'm still looking up that Facebook page. I'm like,
Whip your fingers, Mr. Mellon. Whip your fingers.
I'm 56 years old. I can only go things fast.
And I don't disagree, Mr. Mellon, with what you're saying. Is that we always want to advise candidates and folks that come before us of what the law is. And I think what you're saying is you're advising Mr. Flores, take a look at your Facebook page, make sure you have the proper disclaimers on there, so that we don't have to bring you before here again and get it.
You can add that to the motion.
Okay, if you'll let me do that.
Yes, I'll let you do it.
Okay.
That's fine.
All right, so to add it to the motion is that Flores, based on my initial review, that your website, or not your website, but your Facebook page is out of compliance. Please fix that within a 7-day period, or we'll call you back before it's
Be done today.
That's quick fingers.
That's it. Look at us working. Real people.
Isn't that faster? All right. Any other discussion? Any other discussion? Okay, call for the vote. Roll call, please. And I'm sorry, the motion for the board is to dismiss the complaint and to make sure that Mr. Flores complies with the disclaimer requirement on his Facebook. Roll call, please.
Mr. Brown?
Yes.
Ms. Reardon?
Aye.
Mr. Mellon?
Yes.
Mr. Reed?
Yes.
Mr. Smith?
Yes. Matters dismissed. Mr. Flores, you will comply with the Facebook request. Thank you. Mr. Seeger, we always appreciate you bringing matters to the board. I thank you for bringing that. It's a good discussion. Thank you, Mr. Weezer, for your presentation.
Thank you very much.
All right, Mr. Mellon.
So what are we gonna do with Nick Petrovsky?
That would be for our lawyers to tell us what to do,
That's not our
or anybody else.
And
That's
that
probably
falls under
Just
section
wait till you get a load of him.
Well, I mean,
That
it's
would be
obviously.
under 3-6-5-31, once the board has a substantial reason violation has occurred, or shall investigate. So at this point, since you have that information, issue a notice to Mr. Petrovsky.
All right, we're going to take
I don't know how much more we
we're
can
going to take
go.
a small break. I'll entertain a motion to go into recess.
So moved.
All right, all in favor? Aye. Carries. Clerk Brown seconds that.
I don't know. It's probably like his record. By wearing a forum. That's not a bad spot. Well, at least you gotta go change. I thought you were standing by like, oh my, what's it? No, there's like they ripped on it. It's right on the
You know what? It's
like
It's great.
Maybe the machine.
I don't know.
Or maybe I did on the target. Oh, fancy semi couple years.
Yeah, it's too much.
Do that.
I'm telling you, too much stress.
See, I try to clean all the time.
But Matt, where Matt goes now, he's on the phone.
Oh, it's
This is his elbow because he's on the phone in the car. This is where he blows out shit.
I will. I'll wear a
couple of times. Or I'll wear my suit.
I don't wear
You don't have to. I think it's very cheap. At the end, it's actually a couple times it's okay.
I'm not back.
4 months. 4 months.
I got wraps.
That's what I tell them about machines. They don't always make it into the rotation. So there's
I've years now.
Just about every suit I have, I wear. There's a couple that don't fit me. I
I'm
feel
saying-
like,
saying-
I can get back
Well,
to
I
them.
got, I like to have all the ones I used to have. Fleets. I'm like, oh, are these ever gonna? I can't wear them. I know, I can't wear those. Came back. Yeah.
You're not
They're
going
not, no, not those.
Well,
I agree.
I have a theory about that too. Like, I feel like if I'm gonna get down
Cuffs.
to my small sizes again, then I deserve some shit.
That's a good
And then,
point.
some of my suits I like though that I've had gotten uncuffed that don't have pleats.
The
Like,
shoe
when I
game is
take them
strong,
off,
I
so-
see. I like
Oh,
it.
yeah.
I like the
Tear
socks.
down.
I was actually checking out her socks. I was actually checking out her socks.
I just
My
like
sock game is strong.
It's getting stronger, I think. That's what I
Really.
really.
like I'm trying to help the shoe game.
I like the socks.
So now he's like walking like he's on.
Can you do that?
I just
Because I'm not straight.
you know what? I'm just gonna shoot. I'm just gonna
Newspapers.
I'm just
I love the
that's
hair
what
down.
I'm not gonna say no.
KUS.
And they last longer.
Last row.
He's got it. Spot around.
Go play golf somewhere nice. Got shoe cleaning guy. Throw these up. Give me
Well,
20
no.
bucks.
You gotta go with quality shoes because it's bad for your and your back and your alignment.
Of course, so I'll take the soles out
Eight,
and
Couple times.
I'll put it because I got otherwise I can turn.
That's why I can't wear those.
I
So that's why I
know.
like. So I wear Ellen Edmonds.
Creations.
See what I, you know.
Those are the best.
They're
shoes.
the best.
They are.
But like they're just.
You could just wear them in your
I
house.
got the sandals.
man, if you fix me,
I can't wear the inserts.
when you say
I don't like inserts. So that's why I wear Ellen Edmonds.
Yeah,
Ellen
that's
Edmonds
what's
are
up.
comfortable. Yeah. And put in a.
And put it.
219, 688.
Yeah, you don't have much of a choice. I don't either. It looks like it hurts just to watch.
Especially like your shoes. Like in mine, like you said,
We're not-
what am I trying to?
I look good in What's going on?
Read it.
It's no way.
You have to ask that. They have all that.
Okay, all right. I'll do it. I'll do it.
Oh, thank you.
I get so tired of it. I mean, I know it's your as attorneys, it's what your next case.
That's
Oh my God, that's
I'll
my
wear
big
it. I'll just-
But the
No, we left.
Oh, okay.
Who said? Who hears that? Oh, I don't know. I think you said no.
Exactly. Because I first thought we should have just said.
To me, that was just more. That was just.
That
I
was a
wasn't. I wasn't
procedural
voting. I wasn't voting no on the motion to
because to me it made more sense to get rid of that one
Yeah.
and
And then
hear
just
this.
build it
It
out.
would, yeah, just hear it.
Well, if you would have said that, see, what terrifies me with this is that you're going to go, let's just.
Oh, we dismissed it. Therefore, it's all gone.
Yeah, we're not going to do that.
I don't like procedural tricks. I do not. I like to get it heard. Jim loves it too. I tell you.
It's like, it
It's a
might have died
procedural
out.
trick. I thought that was the best way to get in front of the board. I really did.
Yeah.
Let's
There it
just
is.
see. You have to understand.
Turn it off.
Michael figured out that every time somebody acts like they're doing something nice for you, they're when you're on a golf course and somebody says, "Hey, you want to go? You want to go good? Good.
That's what I was doing. Good. I'm like, oh.
But
I
he said
usually
that
just
about
whisper that to me. I think this is a good.
he said that to me
It's
like
not good.
he said that to me 10 years ago, and it's always true. But always.
When you
That
play
is
golf,
true. That is true. You're good. There's
Oh,
something
you know
bad.
you're good
You doing all right?
when you play golf with somebody,
Well, then you would listen to me. Is this good?
they're always
I'm just trying to get this thing heard. Heard it. We received a response from Mr. Purcell. I'll note that for the record, unless I hear any motions from the board. All right, hearing none, that will be noted for the record that we did receive a response after our turn. Next minute,
To clarify, shall I send the letter before this juncture? Because I did hold off until this meeting, given the submission of those.
and the board's active, so.
Okay, I shall go.
Next matter is old business request for polling change. To my understanding, Mr. Mellon has a motion.
Mr. Chairman Niemeyer had wished to speak on that topic. He is unfortunately unavailable today. He would ask if we could possibly postpone that to a future, or punt that to a future day.
Mr. Chairman,
Clerk Brown.
I will support it, but for the very next meeting, we need to vote on it, because we were ready to.
He will not be available till November, or the January.
That's wonderful.
I would just encourage, maybe we can have a discussion with Chairman Niemeyer, and then even if there's some agreement, we can bring that to the board in December, but if not,
That'd be great. Ideally, that's how these work, is that there's an agreement between chairman and comes to us, and there are two people that have a kumbaya moment, and everybody's happy.
that's what we can come to agreement, great, if not, we'll hear it later date. All right, so there's motion to continue the request for polling change.
I'm
Michelle?
sorry, is this set for December or January?
January.
And then what I would say is that we bring it before the board in December. If Clerk Brown or Jessica or whoever else brings it before the board that they bring some resolution, we can put it on the agenda in December. All right. Before the board, we have a motion to continue this matter. Is there any other discussion? I'm sorry, do we have a second?
Second.
Second by Clerk Brown. Motion by Mr. Mellon to continue the request for polling change. All those in favor, signify by saying aye. Aye. Any opposed? That motion carries. Is there any other old business? Hearing none, new business. Republican Delegate Districts 2026. Jessica.
Chairman Niemeyer submitted the new districts. Seven, yes, district, oh yeah, number 7. So he submitted those, I believe it was last week, I get the date. Those were submitted for some months last.
Is that for approval?
Yes.
Okay. Is it? I
Well,
don't
I
recall.
think it's
Acceptance or no?
acceptance of pattern records that we
Just
can
make
hold
it.
on file.
Yeah, I don't think we've ever approved either party, right? So, okay. So we'll note these for the record, and you want us to move to, you want us to accept them? Motion to accept these, please.
Second.
Motion by Mr. Collins, second by Clerk Brown to accept the 2026 Lake County Republican Delegate Districts. Any other discussion? Hearing none, all in favor, signify by saying aye. Aye. Any opposed? The motion carries. We're supposed to accept the Democratic one. So
They have until December 31st
Thank
in order
you.
to submit.
Thank you. All right, next matter of new business is certificate of election CEB 25 and CEB 9. Who is this?
There, that is the certification of the election. There is a spot on the back of CEB
What number is this? It's number 8.
number signatures.
Okay, I'll entertain a motion to approve the CEB 9 and CEB 25 and certify the election. So moved. Motion by Mr. Reed. Second by Ms. Candelaria Reardon. Is there any discussion on this? Hearing none, all those in favor, signify by saying aye. Aye. Any opposed? The motion carries, and that document is signed by the board. Reconciliation report, special general election. So that's
That is a copy of the reconciliation showing the as to the voting machines. There was 3 that one vote difference. On the first one of Dyer, they had a printing error, it appears.
Dyer 1.
Dyer 1. Dyer 2 was also 1. And then on the last 2 on the back side of the page, those are both certificate errors.
So St. John Township 2 and Hanover Township 2 were
both certificate errors.
All within our tolerances, and anything outside of our variance ceilings would require additional investigation. But these numbers look great. I mean, granted, it was a small election, but they look good.
all right. Well, motion to accept on the reconciliation report for the special general election. Motion by Allen, second. Second by Clerk Brown. Any discussion? Hearing none, all those in favor, signify by saying aye. Aye. Any opposed? The motion carries. Is there any other, I'm sorry.
I have one more
Reed,
item I'd like to
under
add
new
under new
business.
Yeah, we
Yes,
had a presentation several meetings ago by Republican Chair Mr. Randy Niemeyer, and it was concerning. I've probably seen news articles and other items about it during the caucus period during February 27th, 28th. I believe that the Democratic Party had held a caucus for reorganizing in this building, the auditorium, and there is a substantial belief that there were people that worked in other departments and some for the election board office that were participating in the setup and attendance at that meeting while on county time. I will make a motion to refer that matter to the prosecutor and to the, I think, the appropriate authority of the Indiana State Police, just to investigate. I'll make that motion.
I'll second.
the motion by Mr. Reed, second by Mr. Mellon to refer some matter that was presented to the board at some time past to the state police and the prosecutor. Any discussion?
Yes, Mr. Chair.
Clerk.
I was actually in the county council meeting when the county councilman, also known as the county chairman of the Republican Party, presented this information to his fellow council persons, as well as I was in the audience and I was seeking copy. And I do recall him speaking in terms of information only, and by no means was it designed to try to prosecute or cause any harm. It's only designed to try to help get a better understanding of the procedure. So I'm curious as to what was that to this.
Thank you. Any other discussion? I guess I'd like to potentially amend the motion or move to amend the motion to investigate, request the state police and the prosecutor. We're going to send this over to the prosecutor that to investigate how the information was obtained by Chairman Niemeyer that was presented to the board, including video, whether or not that was being used by county time by other employees of the county, to determine how Chairman Niemeyer received the information, received videotapes, received any information regarding people's time cards and things like that, because if this is going to be a partisan witch hunt, I think that then we need to find out who is investigating the matters that Chairman Niemeyer brought before us on county time.
I am more than happy to amend the motion to say that. Perfectly comfortable with it.
Okay, any other discussion?
I'll bet my second.
Any other discussion? Okay, hearing none. John, I think we need to specifically indicate, because you were kind of vague about what we're doing. And
all employees of Lake County government clocked in working on government time that were participating in the setup on February 27th and the conducting and participating in the caucus in this building in the auditorium on February 28th. Whether they be election board employees or employees of other departments. There's video of who was in and out. My understanding, there are payroll records of who was clocked in and who wasn't. That's all I can tell you. It's just I mean, rather than live in a system allows or we're not, or hey, look, if things slip through the cracks and I'm going to send you out to get lunch on county time. I get it. There's slippage here and there. You got to live your life, but this keeps coming up, and nobody really seems to care about
I don't think it was ever presented to us in any other manner that would, other than what Clerk Brown mentioned was, hey, I want to present this to you. We'll come back another day and take a look at this. And I guess this is the other day.
it. This is the other day. I think he also sent us some paperwork this morning.
All right, well, let's take a look.
It said, I'd like you to listen and pay attention because he couldn't be here today. The reason we're in this room is because there's Lake County Council meeting. I imagine he'd be here himself.
All right, so we have a motion and as amended to refer to the prosecutor and state police. That's before the board at this time. I personally don't feel like I have enough information to make a point whether I want to refer. But I'm happy to take it to a vote unless there's any other motion. Any other motion?
Another motion.
I mean, I'd like to, honestly, if I was able to make a motion, I'd motion to table this so we can take a look at this and bring it off the table at the appropriate time so I know exactly what I'm. If we were information that we received today from the chairman, I'd like to look at that.
I understand that request, that this is, that you'd like to review the documents.
We kind of got ambushed on this out of nowhere. It's not on the agenda.
Well, it's hard for us to see something.
Not true. Not true.
But we've never failed.
That's not
We
true.
couldn't put Randy anywhere.
Because we generally don't put him on, but I was happy to give him the courtesy we always do.
But Mr. Chairman, I understand what you're saying. I recognize that maybe we should do an investigation. More information should be presented before we go to vote. So with that being said, I make a motion to table pending additional investigation to our December meeting.
I can second it.
All right, we have a motion table by Mr. Mellon, second by Clerk Brown. Very discussion.
My only discussion is I'd like to actually do this investigation, and I'd like to have the director and the assistant director. We have access there that both the heads of their departments. They can go to the payroll records. They can determine who was in the office doing election board work, who was at the caucus doing that work, and other departments. If they have folks there, they can do the same. But I don't want to say let's do an investigation. We'll kind of come back sometime and maybe we'll talk about it. That's all.
I hear you. I think that's fair. All right, there's a motion to table made Mr. Mellon, second by Clerk Brown. All those in favor of the motion to table, signify by saying aye. Any opposed? The motion carries. Thank you. All right, any other new bills? I don't see any correspondence. Council report, Ms. Brandenburg.
No,
Ms. Tolbert.
No,
Thank you for having the better half of Tolbert and Tolbert here. Purchase orders. Motion to approve purchase.
So moved.
Second.
Motion by Mr. Mellon, second by Senator Reardon. Any discussion? Hearing none, all those in favor of approving the purchase order, signify by saying aye. Aye. Any opposed? The motion carries. The next meeting of this board will be Tuesday, December 9th. I believe sounds like we're going to be at the Lake County Council Large Conference Room. So we're right here at 10 a.m. on December 9th. Is there any public comment? Public comment? Yes, sir. If you could just state your name, stand up. You'll have 3 minutes to tell us where you're from, and give you 3 minutes.
Thank you, sir. My name is Thomas Ostrowski, O-S-T-R-O-W-S-K-I. I'm from Lake of the Four Seasons. 2 comments, sir. On the Seagirt versus Flores event. One question I didn't hear anybody ask Mr. Flores was, once he found that sign up and he didn't see the bud there, why didn't he take the appropriate action to get it taken down? Okay, Chief Flores, why didn't he take it down? Okay, to me that would have been a very important question for the board to ask him. Okay, I understand Clerk Brown stated that there are people that do things without them knowing it and so forth, but as a public official, the clerk knows that it's a violation of the law if that bud isn't there, and I'm sure that Clerk Brown would have seen a sign like that. He would have said, "Hey, look, I had nothing to do with that on my website." Well, The gentleman over here, Mr. Mellon, went to the Facebook site and said, well, wait a minute, he doesn't even have the disclaimer there on his Facebook site, which is a violation of your rules.
Mr. Chairman,
I have to.
I said I didn't see it. I did
Right.
not have
And
time.
he acknowledged-
Remember my fat
And he
fingers.
acknowledged it wasn't there.
There's
And
another
he-
small,
and
there's
he
another
would-
small
he would
question.
put it up
These
there.
presentations doesn't cost money.
Right?
You understand?
Second of all, the question of the gentleman here at the end, I'm sorry, I don't have my glasses on, Mr. Reed, about the investigation and so forth. Now, every public official here at your council will tell you, if a public official recognizes that a law has been broken, that public official has a duty under the law to report that. Otherwise, it's official misconduct. No matter what the law, no matter what the violation is, he has a statute. He has to report it. Okay, if he doesn't, he can be charged with official misconduct. Okay, so when anybody here who works for as a public employee sees that law has been violated and reports it to their boss, they're doing the correct thing. Okay, now the board has deferred an investigation. I would ask the board, the Republicans and the Democrats, to appoint an independent investigator. Get all the information you need from your independent investigators, bring it back to the board so that everybody can see it in writing. Because there was a problem here at the beginning of this board when a case was brought up and nobody could remember what was happening. You have to refer back. So I strongly suggest you both appoint an independent investigator, do the investigation, bring it to the public, then everybody has a complete record of what everybody found and so forth. Okay, then you can vote on either referring it to the Indiana State Police for an investigation, which would then turn it over to the prosecutor, or to the Attorney General. Thank you.
Thank you, sir. Any other public comment? Yes, ma'am. You do whatever you want.
Just outside that door. Close it.
Our reporter can hear you, so as long as they can hear you, we're good. Say your name, where you're from, and get 3 minutes.
Okay, my name is Sheila Majecki. I'm from Sherrville. And I know I'm very grateful that you guys had a lot of agreement today. Some really nice voting. I really appreciate it. It was like the way we used to be. And, but I would like to say, I haven't had a lot of experience with attorneys coming and representing for cases, but I did notice that Steve had an attorney here, and he was very nice and appropriate and respectful. But Mr. Weiser, for all the experience he had, didn't he used to be on your board also? He was kind of loud, kind of rude. If Ron was a different kind of person, he would have been trying to intimidate him. And I know it's not a court of law, right? It's not a court of law. But I felt like I was right in the middle of SVU or something. so I just wanted you to know that. And the other thing, I was really, it was really a nice experience when Secretary of State Diego Morales did his little study of, I don't know, some university came and studied what the prices should be. And it was really nice. We had it all coming together, all of us. And however, Mr. Weiser again, he talked for like a half an hour. We only got 2 minutes, right? We got our 2 minutes, whatever it was. But he went on and on and on. And so did every other elected official. And it left a lot less time for we the people who this is all about, right? And also, if Indiana wants to save money on elections, I guess a poor way to do it. That I could see maybe decreasing a week of early voting or something like that, but to go in there and decrease precincts, it was really a good feeling to have everybody in agreement about that. And that's all I got today.
Thank you so much. Any other public comments? Public comments? Public comment. Show public comment closed. I'll entertain a motion to adjourn. So moved. We have a motion, Mr. Reed. Second by Ms. Candelaria Reed. All those in favor, saying aye. Aye. We are adjourned 11:47. Thanks, everyone.
You want to have one?
That was a long one. Take a breath there.